First of all, thank you once again to HFW and to Schifferli Associates for co-organizing and co-hosting today's event. Many of you would be familiar with the YMP and the Shipping Law Center, but for those who aren't, let me introduce myself. I'm Francesca Cappa. I am currently chairing the YMP in London. The YMP is the Young Maritime Professional Association, which was established by Dr. Aleka Shepard in 2011 as part of the London Shipping Law Center to promote cross-sector networking, education, exchange of knowledge, and further professional development of young maritime professionals across the industry. It is very nice for me to see so many of you attending today, and this is our first event with the Swiss market, so we are very, very honored to host today's event. And I would say that especially at a difficult time like this, it is important as ever that we keep in touch with each other and we share knowledge and experience, especially at an international level. Across our industry. And now, before we commence, I would like to thank once again everyone for attending today and all the speakers, especially of course Michael and Felix for their time. I know it takes of course a lot of time and preparation to put together events such as the one of today. I shall now hand over to Florian, who will be the chairing this session and coordinating the session.
Good morning, everyone, and also from my side at HFW, very warm welcome. I will, as Francesca said, chair today's sessions and will in a moment start introducing our first speaker. As I think has been the format throughout the YMP webinars, we have decided it's probably best to keep questions to the end. So if you have any questions, hold them until the end and they will then be answered. With that out of the way, if I can introduce the first speaker, Michael Buisset, who is the head of the HFW office in Geneva. He is a litigator with a focus on international litigation and arbitration of commercial contracts, and a particular emphasis in this regard on commodities and shipping. Being based out in Geneva, he has a lot of experience dealing with these sort of issues that are being discussed today. And he will start talking about freezing injunctions. And Michael, over to you.
Super. Thank you very much, Florian and Francesca, for the kind introductions. And thank you very much to you all for making time early morning today. And thank you for the Young Maritime Professionals Association for hosting us and having us. It's with a great regret that Anne Chazelle was not able to join us this morning. She was meant to be the third speaker on today's panel, but unfortunately current events and workload have taken her out of action, and she apologizes for not being able to join. But Felix and I will try and cover the questions which we are meant to cover today. And there's quite a lot to go through. It's going to be a bit of a marathon, I'm afraid. But let's start without any further ado. Let me share my screen. Give me a second. So I start with a freezing injunction, but something which we have here in Switzerland. The Swiss version of a freezing injunction and how to freeze Swiss assets. This is in Switzerland something which is covered by the DEBA, the Swiss Debt Enforcement and Bankruptcy Act. And assets can be arrested at any stage in the judicial process and even before the commencement of an action. So it's a very useful tool in order to obtain security for a claim, even before the claim is brought. The procedure involves the filing of an attachment order, which is then served onto the debtors or the garnishees, usually a Swiss bank, and the order will provide that any dissipation or dealings with the blocked assets is prohibited, and there is a threat of a criminal sanction. So it's quite similar to what we have in England. The attachment order is only an interim measure. It is not because you attach an asset that the asset will no longer belong to the debtor, but it is basically a way to block an asset against which you can then enforce an award or a judgment. It doesn't grant you as a creditor a preferential right, but it does ensure that the asset will be there when it comes to enforcement. So it's quite a useful tool. How do we obtain those freezing orders in Switzerland? It's an ex parte application, so the debtor will not be informed of the action up until the asset has been frozen. The application is dealt with on the papers, and it's a summary process, so it's quite a quick decision that can be obtained. And then once the attachment is obtained, it can be served on all relevant third parties. So if it is a Swiss bank, the Swiss bank will be informed and notified of the arrest, asking the bank not to transfer the asset or the money to anyone, pending the court's order. So how do you obtain those freezing orders in Switzerland? It's a prima facie test where the judge will decide whether it's more likely than not that the debt exists and is payable. So you need a prima facie debt, which is due. You need to identify an asset in the jurisdiction. So it can be any sort of asset, but more likely than not, it will be money in a Swiss bank account. A few years ago, I was able to arrest a letter of credit. So funds that were transiting via a Swiss bank under a letter of credit. So it can be money which is just transiting via a Swiss bank, but you need to have the information, of course, of the transfer. So it needs to be money which belongs to the debtor, and there needs to be a case for arrest. So let's have a quick look what you need to show in order to have an arrest granted. We have various scenarios which are contemplated, but really the most common and the two main scenarios are those two here. So you have to show that the creditor has an award or a judgment which is enforceable. So if you have an enforceable award in hand, you can just move against the money and an arrest without any further test. The second test only applies to non-Swiss domiciled entities. So if you have identified assets in Switzerland, but your debtor is not based in Switzerland, then you can move against that asset even without an award or an arrest, so as pre-judgment security, but you can only do that in two scenarios. If your counterparty has acknowledged the debt, it's quite a formal way of ascertaining that. It needs to be a written recognition of debt with a handwritten signature. So it needs to be wet ink. And so it can't just be an email from your counterparty saying, oh yes, I pay your debt, don't worry. It needs to be something a bit more formal with a written signature. But if you have that, this is sufficient in order to move against any asset the non-Swiss domiciled party has here in Switzerland. Or the other test is that the debt has a sufficient nexus to Switzerland. So you have a claim, it hasn't been acknowledged, and you will need to convince the court that it is just and proper to arrest because there is a link to Switzerland. That is not just a mere presence of assets in Switzerland. So it's not because someone has a bank account in Switzerland that will be sufficient to show a nexus to Switzerland. But if you have a contract which is subject to Swiss law, for example, or if the negotiations were held in Switzerland, that might also be a useful argument. Often attachments are used as a first step to enforce awards of judgments in Switzerland. My colleague Felix will tell you about that in a short moment. But what is important for you to take away for the moment is that in order to start enforcement proceedings in Switzerland, you don't need to have a separate recognition of your foreign awarded judgment, and declaration of enforceability is not needed. All you do is you move against the asset under this debt collection procedure and attachment procedure. The bank, for bank account arrests, there is no need really to identify the specific bank account. You don't need to have the bank account details, but you need to identify the financial institution, obviously, and you need to provide prima facie evidence that there is a banking relationship between the debtor and the bank. So you can't just serve all the banks in Switzerland hoping that you grab some money. You have to showcase a relationship on the papers. Now, also important to remember is that you cannot use this against Swiss domiciled entities pre-award judgment, but it can be useful if your counterparty is not domiciled in Switzerland but has assets here in the jurisdiction. So this is as much as I wanted to say about attachment of assets. We'll leave the questions to later on, and I'll carry on just with the second subtopic, which is Swiss debt enforcement proceedings. Here again, we have a very interesting procedure in Switzerland, which allows you to move against a debtor without much evidence at all at the beginning. So you can commence your debt enforcement proceedings without any evidence, and you only need to provide evidence if you have a debtor who objects. It's an independent procedure here in Switzerland from any substantive proceedings on the merits. And if the debtor files an objection to your notice, then of course the procedure is suspended until a decision on the merits has been served. But in our experience, serving a summons to pay here in Switzerland can be a very useful tool to apply pressure on a debtor. Because essentially, before you start a claim, or in parallel of starting a claim on the merits, which could be a claim on an arbitration in England or elsewhere, just serving a summons to pay here in Switzerland automatically applies pressure on your Swiss-based counterparty if the debtor fails to object within a very short time limit of 10 days. And it's happened to us on numerous occasions where a Swiss-based trading company or shipping company, which only has a letterbox here or hasn't got the resources to respond, lets that time limit lapse, and therefore become subject to a very summary kind of procedure on debt collection. So it can be a very short way of recovering sums due by a debtor in Switzerland, and it automatically applies pressure without much work to be done on the claimant side. It's the same procedure everywhere in Switzerland. Again, it is a procedure which is regulated under the Swiss Federal Act on Debt Enforcement and Bankruptcy, nicknamed DIBA here in Switzerland. And so how it works is that you don't need a judgment or an award or an acknowledgement of debt to start a procedure. You only serve a notice to the local debt collection office in the canton where your debtor is domiciled. And so yes, you have a debt collection request, which you serve in French. In Geneva, we call it the réquisition de poursuite. It's filed by the creditor with a local debt collection office. So here it's the Office de poursuite in Geneva, at the place of enforcement. So that can be different from the place where the merits are going to be heard. It might be heard at the place of enforcement, but your merits may well be subject to an English arbitration award or a Swiss judgment. But you serve the debt collection request in the place where you want to enforce, where the debtor is domiciled. So the request is quite simple. It includes the debtor's name, the debtor's address, the value of the debt, and the reason of the debt. The debt collection office, the Office de Poursuite, will then record the debt in the debt collection register. So already you apply pressure here on a debtor and will notify the summons to pay, the commandement de payer, to the debtor, summoning him to pay the requested sum within 20 days. Upon receipt of a summons to pay, a debtor will have three options. Either he pays the full amount, and then the debt can be erased from the register, or he does nothing, and the creditor will be able to submit a request for continuation of the poursuite, réquisition de continuer la poursuite, after waiting for 20 days. So after 20 days have elapsed, the procedure will continue if the debtor has not done anything about it. If the debtor, however, files an objection notice, which has nothing formal about it, it's only a simple objection without any reason, that is the opposition au commandement de payer, within 10 days of its notification, then the procedure is stopped. The creditor is then required to go to the court in order to lift this opposition. That's the main levée d'opposition. So it's a very simple process. You serve a notice. If the counterparty responds within 10 days, then you have to go further. If he doesn't respond, then you're able to continue the poursuite on the summary basis. Otherwise, you will have to commence proceedings on the merits. And you will have three ways in which that opposition can be lifted. So if you already have a judgment or a arbitration award in hand, then you can simply ask the Swiss authorities to issue a main levée définitive, so to lift the objection because you already have a judgment or an award in hand. You can file an application to the Swiss court to obtain a judgment lifting the objection, also if you have a recognition of debt from the debtor, main levée provisoire. So if there's no dispute about the debt and you have a document or a contract, a written contract or a settlement agreement or anything which shows the amount due, then this also allows you to go back to the Swiss authorities and ask for this opposition to be lifted. And thirdly, if you have neither of the above, then you need to commence proceedings on the merits, in French, une action en reconnaissance de dette, before the judge or arbitrator who has jurisdiction to hear the merits. That decision can then be enforced in Switzerland to lift the objection, and then you have a main levée définitive. If the objection is lifted, the debt collection procedure continues, but only if the creditor then files a request for continuation, réquisition de continuer la poursuite. Upon the request for continuation, the debt collection office will then send a notice of compulsory liquidation or a seizure notice. So as you've seen, it can be a summary procedure, and it can be quite a nice way of applying pressure on a debtor. But of course, if the debt is contested, or if you're dealing with a sophisticated Swiss counterparty, then they will no doubt oppose the request, and then you will need to push your claims through on the merits. But nevertheless, it's a useful tool and one we use quite often here in parallel in order to apply pressure on prevaricating respondents or defendants. This is as much as I wanted to say about the Swiss debt enforcement procedure and DIPA. Now, DIPA, I would like to hand the microphone back to Florian to introduce our next speaker, my colleague Felix Neri.
Thank you very much, Michael. Yes, the next speaker this morning is Felix Neri. He is a Swiss lawyer and partner with Schifferli Associés in Geneva. Apologies. Felix represents clients in both court and arbitration, and in the context of both domestic and international disputes. And he or his practice has a particular focus on white-collar crime, as well as asset tracing, freezing of assets, and recovery of assets. So again, a lot of experience in today's topic, and as such, without further ado, over to you, Felix.
Thank you very much, Florian, and thank you, Michael, for kickstarting this presentation, and thank you for everybody who have got up early this morning to listen to us. If you'll just give me a couple of seconds, I will put on our slides, and this should be it. Yes, here we are. Right, excellent. So in today's topic, we will be discussing the enforcement of English judgments in Switzerland post-Brexit. So I'd like to address, of course, this issue, which I will keep in this presentation as short and as high level as possible, because, as you will all appreciate, this is a very complex matter, and it is, of course, something that I could spend hours talking to you all about. And the main issue, of course, here is that the situation is a bit complicated from various aspects. I just have one issue with my PowerPoint presentation. Just bear with me 1 second. Sorry. I'm sorry, I cannot keep, wait, can I get to the slide? Yes, sorry, apologies for this. Yes, so the first thing I wanted to talk to you about and remind you all is that there are, of course, a couple of key dates that are very important here in this particular topic. The first being, of course, the exit of the United Kingdom from the EU, which took place on the 1st of February 2020. Now, when the United Kingdom left the EU on that date, it also left key conventions, and one of which was the 2007 Lugano Convention on Jurisdiction and the Recognition and Enforcement of Judgments in Civil and Commercial Matters, that I'll refer to in this presentation as simply the Lugano Convention. As a result, litigants have been facing uncertainty as to whether the Lugano Convention would continue to be applied by Swiss courts, or whether the default federal private international law act, known in Switzerland as the Pillar, would apply instead. And so, as some of you may know, for the time being, and I'd say despite the United Kingdom's request to rejoin the Lugano Convention, I think at some point in April 2020, the European Union has denied the United Kingdom's rejoinder during the summer of that same year. And I should mention, despite several other countries being favorable to that rejoinder, including Switzerland. Now, the second big date that I'd like you all to remember, because it has an impact on litigation here in Switzerland, is the end of the so-called Brexit transition period. This period obviously came to an end on the 31st of December 2020, and it ends the transition period agreed between the European Union and the United Kingdom. It is relevant too, obviously, because the Swiss Federal Office of Justice, which I'll refer to as the FOJ, has published guidance on the application and on the position of Swiss authorities in relation to the Lugano Convention. And of course, though many Swiss scholars and some courts have aligned themselves on this principle, the FOJ's guidelines are not binding. And so this means that Swiss judges can very easily simply choose to either choose a different interpretation or apply a different kind of case law. And so it is problematic for litigants, as it does not offer, I'd say, clear and final guidance as to how to deal with recognition and enforcement of UK judgments. Now, the last date that I'd like you to remember here is the 22nd of March 2021, which signifies the handing down of a landmark judgment by the Swiss Federal Supreme Court, which was ultimately published on the 28th of July 2021. Now, this judgment is, of course, highly relevant to the topic at hand, because it is, I think, the only instance where the FSC actually discussed the application or non-application of the Lugano Convention when dealing with judgments rendered in the UK post-Brexit. Also, for those of you who do not know this, the Swiss Federal Supreme Court is the ultimate fourth instance of the land. And so that means that it provides my country's case law. And incidentally, it also provides guidance as to how certain rules of law are to be interpreted by practitioners and lower federal or cantonal courts. And so this makes this particular decision, I'd say, critically important, as it offers some guidance on the application of the Lugano Convention post-Brexit. By way of background, and I'm not going to discuss the full contents of this judgment, it basically refers to a monetary claim that was brought by claimants originally before London courts. They were successful in securing a judgment that they then wanted to have recognized and enforced in Switzerland. And this is typically the way recognition and enforcement proceedings are used in Switzerland by foreign claimants. I'd say it's therefore a particularly important case that has generated, I'd say, many legal newsletters last year, and is definitely worth reading should you be interested to do so. Next up, we have, of course, the nitty-gritty question of when does the Lugano Convention apply? So according to this judgment, the Lugano Convention does apply strictly in a special and particular circumstance. That is to say, if you have a judgment that's obtained in the United Kingdom before Brexit, i.e. before 1st of February 2020, and that a recognition and enforcement proceedings have been continued. Yeah, sorry, apologies, you didn't see the slides. My apologies. I think they are all visible to you now, which is good. So this is important in the sense that it gives you some idea of how the Swiss Federal Supreme Court has viewed the application of the Lugano Convention. And therefore, on that basis, you have some certainty when you're dealing with this particular casus belli. However, I would say that there's still uncertainty in the sense that this FSC judgment does not offer clear guidance in relation to other case scenarios. For example, the big question, what happens if a UK judgment was rendered before the end of the transition period, but the recognition and enforcement proceedings were commenced in Switzerland after the transition period, i.e. as of the 1st of January 2021. This is a question that has often been raised by practitioners, and so far we have not received any satisfactory answers to it. Unfortunately, Swiss scholars are, I say, in addition, divided. So there remains a big degree, I say, of uncertainty as to how the Lugano Convention is to be applied even during the transition period. Of course, what we do know is as of the 1st of January 2021, the Lugano Convention will not apply to the recognition and enforcement of any judgments rendered after that transition period. Sorry, went too far. So you may ask what happens next. I'd say that apart from the uncertainty of all of this, what is certain is that absent a separate treaty between the United Kingdom and Switzerland on this particular issue, the default rules of the pillar will apply in full. Now, what is not absolutely what is not absolutely clear is how this will impact litigants bringing enforcement, recognition and enforcement proceedings. I would say here that there is a problem because obviously the conditions provided Article 25 of the pillar are much more stringent. And on this particular note, I would like to add that the enforcement and recognition of interim measures, and especially freezing injunctions, will not be as straightforward as under the Lugano Convention. And the fundamental reasons for this is that the pillar framework requires that the decisions to be recognized and enforced under Article 25 letter B of the pillar it makes it all much more complicated. So interim measures by essence do not sit well as regards that particular requirement. Another possible hurdle is that the pillar refers to foreign decisions and that the interim measures are not necessarily accepted to fall under this designation. The fact that Swiss scholars are divided on the subject and that the FSC has yet to clarify this specific issue and that the cantonal court jurisprudence in addition is not consistent does not help offering us proper guidance. So I would say that we are now facing, of course, very difficult times, in particular with the Russian invasion and the war in Ukraine. So one would wonder what will happen now, and there is, of course, no certainty as to whether these geopolitical shifts will, in fact, mean that the European Union and the UK relations will get better, and that the European Union may reconsider to bring back the United Kingdom into the Lugano Convention fold. There might be some rapprochement, I'd say, between former rivals, that maybe a reconsideration of past, essentially politically motivated decisions here. That being said, I think we can all agree with the sanctions, with all the problems that are that we are facing right now in the world. There will be more litigation, and if there's more litigation, there will probably be more judgments to be enforced in Switzerland, and therefore we can expect, if not in the weeks to come, in the months to come, that there will be more requests for recognition and enforcement of foreign and especially English decisions. In the meantime, I would say litigants contemplating enforcement and recognition of UK decisions and judgments in Switzerland must proceed with caution. And on that, I have finished my presentation on the subject of the enforcement and recognition of UK judgments post-Brexit. And I hand over the mic again back to Florian.
Hi, thank you, Felix. We are both going to speak about the use of English worldwide freezing orders here in Switzerland and how they have been perceived both by the local courts and by the local community, and what an impact they had and how they were interpreted here in Switzerland. Let me resume the slideshow. Here we go. Can you see the slide? Super. So those are what we, of course, call Mariva injunctions in the UK, and what has been largely seen as the atomic weapon for securing payment of awards or judgments in the English High Court arsenal of enforcement. Now, theoretically, worldwide freezing orders have an extraterritorial effect. However, in our experience, the Swiss community has reacted quite disparately to those worldwide freezing orders. So let's just quickly remind ourselves what the test is in England. to obtain a freezing injunction, a claimant needs to prove that there's a real risk that the judgment or award in favor of the claimant would remain unsatisfied if the freezing order and disclosure order is not granted. So that's actually the most straightforward route to obtain a WFO. You have an award in hand, you have a judgment, which you then bring to the High Court in order to obtain a freezing order on the basis that you've been strung along in the proceedings, the debtor, respondent, or defendant has perhaps participated, promised to pay, but then left you hanging. And then on that basis, you have a good chance on the papers or on the evidence to obtain a freezing order and a freezing injunction. The other route is to show that your debtor may dissipate assets. So you have to evidence to the court that there is a real risk of dissipation of assets otherwise than in the ordinary course of business. So that is when usually you try to obtain a freezing order before you have an award in hand or a judgment in hand. And in that case, you need to show that the respondent or the defendant is likely to transfer assets out of the company in order to avoid payment under a future award or judgment. So that's the test, which is well known to us. Now, how is this working in practice? Where we have obtained a freezing order in England, you then have a notice which you're entitled to send to the debtor's trading partners or the banks here in Switzerland, which prohibits the conduct of business with a creditor within the terms of the order obtained. And of course, this has a colossal impact on the creditor's ability to trade. However, in our experience, serving such a notice can give rise to huge tensions here in Switzerland. And we've had a number of banks who we served with freezing orders who have highlighted the fact that whilst the English courts consider they have extraterritorial jurisdiction in issuing those orders, the Swiss courts might sometimes disagree. Now, why is that? Let's look at the penal notice. And it's quite important to remind ourselves of the actual wording of those notices. So if you name the debtor, disobey this order, you may be held in contempt of court. So it's quite a severe warning, and maybe fined or have your assets seized. Then if your debtor disobeys this order, the directors, so you now incriminate the directors themselves, not just the company, but the people, the officers of the company who control the debtor, they also may be held in contempt of court or maybe imprisoned. So you have a custodial sentence attached to this notice. And here is the third limb, which is actually the most potent one, because you serve this on the trading partners and the banks. Any other person who knows of this order, well, they know of the order because you served it on them, and does anything which helps or permits the debtor to breach the terms of this order, may also be held in contempt of court and may be imprisoned, fined, or have their assets seized. So this, if it's served on a bank or a counterparty, has the colossal impact that that trading party or counterparty will stop trading in order to avoid being in breach of this penal notice. Of course, the Swiss courts or any other court on the continent will not put the directors in prison, but it will have an impact if that individual will enter the UK. In the UK, this notice will be valid, and travel to the UK for someone who has been in contempt of court or have been in breach of this order will be enforced. So that is where the tension arises from our perspective, is that you, irrespective of what the Swiss courts may think and how it applies here in Switzerland, under English law and for the purpose of the English courts, being in breach of this order anywhere in the world puts you in contempt of the English High Court, and with the consequences that entails. But we wanted to discuss with you and with Felix how this problem is actually solved in practice. I mean, in our experience, we've had some pushback from some trading companies saying this may not be enforceable in Switzerland. However, usually the way around it was to say, well, it doesn't matter whether it's enforceable in Switzerland, it's still something which touches you and applies to you insofar as it's an order from the English court. And if you want to travel to the UK on leisure or business, this may have an impact. But I'd be very interested to hear from Felix on how the Swiss courts have interpreted this in recent years, and what the Swiss judges make of it, and how this may evolve in the near future. Felix, you may have some slides as well you wish to share.
Yep, sure. Hang on just a minute. Yes. Can you see my slides this time? Yes.
Yeah.
Here you are. So thank you, Michael, for that brilliant presentation as to how these WFOs are engineered, if I may say, in the Anglosphere. Of course, coming back to Brexit, there have been, I'd say, several hurdles already facing litigants who were trying to have recognized and enforced WFOs in Switzerland under the Lugano Convention. And this is why I'd like to briefly remind everyone how the system effectively worked under the guise and system of the Lugano Convention. As I mentioned, I think briefly before, pre-Brexit, the recognition and enforcement of interim measures, which of course encompassed, historically speaking, WFOs, was straightforward. That is to say that you would have pretty much a straightforward process as per Article 32 of the Lugano Convention, whereby these interim measures, be they freezing orders or freezing injunctions, or of course worldwide freezing orders, were recognized as decisions as per that Article 32. And they were in principle recognized and enforceable if certain conditions were met at Articles 38 to 56 of the Lugano Convention. The FSC, in addition, did rule that the WFOs could be construed as such interim measures and did qualify as decisions under the Lugano Convention. So we didn't have, shall we say, any problem from a theoretical perspective in having WFOs recognized and enforced in Switzerland. Now, of course, that did not mean that the process was a straightforward one at all. And in fact, in Switzerland, the main issue here was the way Swiss courts effectively had limited case law about the enforcement and the recognition and enforcement of foreign interim measures. Fortunately, as far as WFOs were concerned, and perhaps unsurprisingly to everyone, they were an exception to the rule in the sense that there has been many cantonal precedents about how one should approach WFOs. However, that being said, the diversity, I would say, in the approach of to WFOs by cantonal judges, and sometimes the radical shifts in viewpoint from one judge to another in the same cantonal court were significant. And this did not help draw a clear map or path for litigants seeking the recognition of it and enforcement of WFOs in Switzerland. I'll give you a brief example of this, in that historically, Geneva courts used to refuse, I'd say rather systematically, the recognition and enforcement of WFOs. And that trend changed around 2017. On the other side of the country, if I may say, and of course, as another great hub for litigation, Zurich courts, on the other hand, used to be quite open to the recognition and enforcement of WFOs, but in recent years became more reticent. So that, of course, gave everybody's task, especially Swiss lawyers, a task very, very difficult, in that there was a high risk that depending on which judge you before, there would be a different reception. I'd say this, however, there was some consensus in that most of the courts agreed that WFOs that comprised what we called an angel bail clause would not be recognized and enforced. For those who do not know, such clauses form part of the English commercial court standard form for freezing orders. And I cite here one example of wording. And typically an angel bail clause would mention that, for example, this order does not prohibit the respondent from dealing with or disposing of any of her or his assets in the ordinary and proper course of business. But of course, before doing so, the respondent must tell the applicant's legal representatives that it is seeking that. And so an angel clause aims to avoid the situation of a freezing order preventing a respondent from carrying out its ordinary business dealings. So far so good. That makes, I suppose, some degree of sense. But that view was not shared by most, if not all, of the judges dealing with them, because they sensed that there was a problem with the imprecision of the order, and as such would not accept to recognize and enforce WFOs that contained these so-called angel bail clauses. So what is the approach to WFOs in Switzerland after Brexit? As I title it, well, this is a bit the great unknown. Unfortunately, there's, to my knowledge, no clear case law on the treatment of WFOs post-Brexit. And so this leaves litigants and their Swiss lawyers in greater limbo, if I may say, as the court precedents that I mentioned before, of course, exist, but do not offer, even under the auspices of the Lugano Convention, clear guidance. In addition, to make, I'd say, matters worse, WFOs under the pillar regime will face some significant hurdles in terms of recognition first and then enforcement. As I discussed this morning, the default rules applicable to post-Brexit UK judgments, decisions, and of course interim measures are now contained in the pillar. And the main problem I see with this is that the pillar, that if you apply the pillar, the notion of WFO, which quite rightly is assimilated as an interim measure, may not be accepted as a foreign decision as per Article 25 of that Act. Moreover, the pillar requires the decisions to be final, which, as with interim measures generally, I cannot see as being easily demonstrable at all. So it follows that the impact of Brexit could make the recognition and enforcement of WFOs in Switzerland even more difficult. And I'd say this again, that given the complexity of the new and transitory procedural framework, litigants would be well advised to consider the Swiss means of relief, which are varied, and that Michael discussed early on in his presentation, and that would at least offer, for at least in most part, greater predictability. Now, what we are all hoping for here in Switzerland, I speak for myself, I speak probably for litigants and most lawyers and courts even, is that the FSC at last provides the general public with a much awaited obiter dictum in which it would clearly and finally draw, I'd say, the conditions and the frame in which WFOs are either admissible or not admissible, and under what conditions. Sadly, we are still waiting for the FSC to render such judgment. So ultimately, and I conclude on this note, for the time being, litigants should tread with caution when contemplating initiating recognition and enforcement proceedings, be they for substantive judgments on merits or interim orders in Switzerland. And I'd say in particular with regard to WFOs, as it is a particular beast, which historically speaking, a lot of judges here in Switzerland, and not only in Geneva, have had trouble accepting. So how do you go about this? Well, probably the best thing to do is to consult a good Swiss lawyer so that he can pave the way for you when you contemplate further litigation. It has been my pleasure presenting today, and I thank you all for your kind attention.
Yes, thank you very much, Michael and Felix. we now open the floor to questions, and I think there are two ways to ask questions. The one is the chat function, sort of to write the question in there, or to press the raise hand button somewhere on the screen, which would then allow that person to be unmuted and to pose the question. So if I give it a moment to see whether we have questions coming in on the chat function or whether someone is raising their hand. And someone correct me if I'd missed something now.
We have 7 minutes left. Don't be shy to ask any questions. It's free legal advice on a Thursday morning. There's no doubt that the world has changed drastically in the last 5 years. I moved from Singapore to Geneva about 7 years ago. And the world has been in a state of flux since then. I mean, Brexit was the start of a geopolitical change. What is happening in the Ukraine is abhorrent. The level of death and destruction and suffering that is being inflicted is unacceptable, and this will have consequences on the geopolitical framework. You have a lot of businesses in Switzerland which are heavily invested in that part of the region, in part of the world, and we're already seeing the disruptions, certainly in the shipping markets and in the trading markets that the invasion has caused, and the sanctions regimes that are being applied are unprecedented. I mean, we are moving from one unprecedented crisis, a pandemic, to another one. And this will have a huge impact on Switzerland, on the trading community and the shipping community here. As Felix said, there will be more uncertainty. There will be more litigation, and it will be a more difficult environment to navigate in order to preserve your rights as a company or as a trading entity. And trading with caution is certainly what we would recommend as well on our end, certainly from the sanctions point of view, from the banking point of view, the payments that can be done, and with whom you're doing business.
Then I think we've had. Sorry, we've had one question come in. Actually, it's two questions coming in now. The first one is, due to fiscal secrets in Switzerland, it's difficult to assess financial good standing of a debtor counterpart. Is there any way to obtain a copy or copies of balance sheets in a way other than criminal or fraud allegation or spontaneous disclosure?
Michael, I'm happy to take that one if you like. Well, the short answer is probably not. There is, and I mentioned this, a particular tool in Swiss civil proceedings, excuse me, which does allow litigants to request a disclosure of certain documents. Unless I'm mistaken, that those particular rules are provided in the CPC, which is the Swiss procedural code on civil proceedings, the articles, I think 163 and following. Anyway, the problem with that, and I've written an article about it, comparing the disclosure system in the UK and that of Switzerland, is that it is mostly, I'd say, a big shark without any teeth, in that you cannot, if the other side refuses to provide the documents and this information, you cannot really pressure them further. In the sense that, unlike the English system, there is no negative inference default rule for those who do not provide information spontaneously. Rather, the approach by Swiss courts is, if you are going into battle, you have to come in fully armed as a claimant, and you have to have your supplies with you, in the sense that getting information from the adverse party is not as difficult. So To answer your question, I think quite quickly, I think it is very difficult if you do not go, especially through the criminal procedural law avenue, procedural situation where, of course, a prosecutor can order a third party or defendant to hand over any document in its possession. And of course, you as a plaintiff party, recognized as a fully authorized criminal plaintiff party, would have access at some point in the investigation to those documents, and more perhaps importantly, you can use them without pretty much any reservations in other jurisdictions and in other proceedings in which you are engaged.
Thank you very much, Felix. We've got one other question at the moment. I think it's also one for you probably, and that is, are the estimated costs and time for the enforcement of English judgments not governed by the Lugano Convention expected to significantly increase?
Well, thank you for that very easy question. In my view, the net simple answer to that is yes, it will take a lot more time, it will be a lot more expensive. And as I tried to explain to you today, perhaps more significantly, the phase of recognition, so to speak, which used to be a formality, will not be so under the pillar rules. Quite the opposite, and that is why our advice to clients now, when considering proceedings, and given that we have limited imperative case law on the subject, is to explore Swiss means of relief, and those have been addressed brilliantly by Michael earlier this morning, especially if you're looking to act quickly and efficiently to secure assets. And I'd follow up on what Michael was discussing this morning, especially when you're dealing with trading counterparts, trading defendants. One of the great things with Swiss freezing injunctions is that as soon as you have located the bank, ideally the accounts, and even more ideally that you know where the trading accounts are, the ones that the defendant uses to trade on a daily basis, you can ask the judge to freeze those accounts. And if, for example, the quantum of your original claim is, say, £200,000 or £1 million, quote unquote, a relatively low figure, if the judge accedes to your initial request, he will order the freezing of the accounts in full, which means that if you're dealing with trading accounts on which hypothetically the defendant is trading on a daily basis millions or tens of millions, hundreds of millions, that account will simply be blocked. It will not be available to the defendant. And the jerk reaction I've seen in practice is that you very quickly get a call from either the defendant's GC or from its CEO or from someone with authority, saying, well, basically, how much do you guys want? And can you quickly write to the Swiss judge who's decided this freeze to have the freeze rescinded? And so, of course, that is a fantastic tool because I'd say within the space of a week, you can not only recover all the monies you have claimed, but obviously all the fees and costs of the request for what we call civil attachment of assets before the court. So for claimants, this is, I think, a very interesting prospect, and it is particularly diabolical when you're dealing with trading companies.
Thank you very much, Felix. I think I can't see any more questions or raised hands, and given that we have reached the hour mark, unless someone comes up with a question fairly quickly, I would like to take this opportunity to thank both Michael and Felix for their time this morning and the time that went into preparing the presentations on relatively current topic with everything that is going on in today's world, and thank everyone who attended today's webinar. Thank you very much for their time, and a pleasant morning and rest of the week. Apparently there's one more question, I've just been told. Have I missed something? Oh, no, I can't see. I know there's one more question, so last question, and then we'll conclude. What about facilities agreements and credit agreements done by Swiss banks together with EU banks? Is it still safe to apply UK law?
Yes, let me briefly answer that question. It depends very much on the terms of your facility and credit agreement. If it is subject to arbitration, then it is not a problem. I mean, we don't see that Brexit has had any impact or will have any impact on the application worldwide of English law. It's been a well-tested law to apply between counterparties who know what the answers are to the various issues that can arise under an agreement. So we don't think that the law itself is a problem. What we have identified as being a problem, or for the moment being a cost, an extra cost and time issue, is really the enforcement of your judgments, which are issued by the English High Court. So the law itself will continue to be the law used by everyone in the world. If you have a Greek ship owner and an Indian charterer or trader who wouldn't trust each other's legal systems, they would trust English law, and therefore the law will continue to apply. But however, in arbitration, it's not a problem. You have the New York Convention, which will deal with the enforcement of English arbitration awards. However, if your agreement is subject to English High Court, then either you may wish to change that to an arbitration agreement, or you may wish to just bear in mind that your English judgment will not just be automatically enforceable in Switzerland without a Swiss judge looking at the validity and legitimacy of the judgment in the first instance, which may mean that your enforcement will take a bit longer than it would have done under the Lugano Convention. But certainly, we don't see any reason to change agreements from English law to any other law for the moment, because it is a well-tested system and a well-precedented law, which people have been very, very familiar with over hundreds of years. But yeah, you just need to be bearing in mind that in terms of English judgments from the High Court, you might have a few further hoops to go through before you can enforce those in Switzerland. And if they're not huge hoops, you won't have a new hearing on the merits. You will only have a judge taking the time to look at how the judgment was issued and formally enforcing it.
Thank you very much. Just one final question. Maybe this is a good way of summarizing or sort of bringing the session to an end. And that is effectively, is there consensus as to whether the UK will get back into the Lugano Convention fold?
Consensus among us. To be honest, I would say this. What we've all been experiencing beyond the horror of this war and beyond the tragedy of it all, from a judicial perspective, is and I usually use measured words. I think rather crazy developments. Of course, the first being sanctions. That is to say, you have people who are being sanctioned left, right, and center, and no one really knows why. That's the first point. Second point, the reaction, I'd say knee-jerk reaction of, in particular, my government, which has been, as you all know, neutral right up until this this war, has also, through its various offices, made certain radical decisions. Now, one that I note, because I know some of you deal with Russian clients, some of you may be knowledgeable or involved in criminal proceedings, is that the Swiss authorities have taken a rather unprecedented step in simply refusing, from now on, mutual assistance in criminal matters with Russian authorities. So that, for me at least, and my firm, as we are specialized mainly in white-collar crime matters, this is a huge development. It's not one that has been discussed in the press, and obviously, for those who know Switzerland, we have referendums and initiatives pretty much every month, and no one has asked our opinion about whether this is a good idea or not. So we have seen quite, to come back to your question, we have seen some quite amazing developments here. And we also note, at least in the press, that the European consensus is to hold rank, especially vis-à-vis the United Kingdom and the EU. And despite Brexit, despite many problems related to fishing and other matters. So there is a possibility, I think, maybe not immediately, that some of the minor issues, topics might be dealt with swiftly, and perhaps, and this is my hope, that the United Kingdom will rejoin the Lugano Convention, because that will give all of us, I think, an easier way forward in advising our clients, and I think it will relieve, for the judges I know, quite a few of them, as they do not like applying the pillar to these sort of matters. That's my view. Over to Michael.
Yes, I totally agree. It's unnecessary uncertainty, and you would hope that the kind of geopolitical shifts worldwide would ensure a rapprochement between the EU bloc and the UK again, and certainly for issues of enforcement such as those which have worked very well between various judicial systems. The UK will jump back on the Lugano bandwagon before long.
Thank you very much, both. We have now, I think, exceeded our time slot by quite a bit. So again, thank you very much, Michael and Felix. Thank you very much, everyone, for attending. Thank you very much for the very interesting questions. And from the YMP, I think we'll be in touch shortly with our regular email updates on when the next event will take place. And until then, as I said previously already, have a good day and a good rest of the week. Thank you very much, everyone.
Thank you, everyone.
Thank you, everyone.